video will provide information on powers of attorney, specifically financial powers of attorney. You may give someone a power of attorney to make healthcare decisions for you, but that is a discussion for another video. What is a power of attorney? It is a document in which you give someone the right to act on your behalf to make financial decisions for you. In a power of attorney, you, the person making the document and giving the authority, are called the principal. The person receiving the authority from you is called an agent or an attorney in fact. Who should be your agent? Someone very trusted, as they will be making financial decisions for you. There are two methods to make a power of attorney in the state of California. The first is a form. It is found in the California Probate Code beginning at section 4400. It must be filled out completely and notarized. You can easily find this form online. It also contains a list of all of the powers that you can give to your agent. The form is recognizable to financial institutions and other entities, and so it is readily accepted. You can also create a power of attorney for yourself without using the form, and the rules for that can be found at Probate Code section beginning at 4100. If you make it for yourself, it must contain the date of execution. It must be signed by you or another adult in your presence and at your direction. And it must be acknowledged by a notary public or witnessed by two witnesses. If you decide to have your power of attorney witnessed, the witnesses must be adults, and the person you are naming as agent cannot be one of those witnesses. The witnesses must also see you sign your power of attorney. When you make a power of attorney, it can be effective immediately, or it can activate upon certain events, such as when you become incapacitated, if you are deploying overseas, or if you're going into the hospital. This is called a springing power of attorney, as it springs into action on the stated event. Another type of power of attorney is a durable power of attorney. It is one that continues to operate even if you become incapacitated or are unable to manage your finances. If you are making the power of attorney to allow someone to take care of your finances when you are no longer able to do so, then you must make it durable. If you do not make it durable, then the court will need to appoint someone to act on your behalf. What powers can you give to your agent? You can essentially give your agent powers to make all decisions related to your finances, such as real estate transactions, including renting property, banking, investment decisions, and securing many public benefits. Again, because these are such broad powers, your agent should be someone you trust very much. It is important to note also that your agent owes fiduciary duties to you. This means they must act only in your interests and cannot take the assets for themselves. A power of attorney terminates automatically at your death. Your agent cannot use the authority once you have passed away. Thus, you will need further planning to allow someone to act once you die. You can revoke your power of attorney at any time, but be sure to alert your agent and anyone you know or think you know that has a copy of that power of attorney, so that the financial institution or any other person knows that your agent can no longer act for you. Finally, a power of attorney operates over assets in your own name. If you have a trust and have titled assets in the name of the trust, then your trustee controls those assets, and your power of attorney has no authority over them. If you are concerned about how your finances will be managed if you are unable to make financial decisions in the future, then you should consider making a power of attorney, and the form power of attorney is an easy option to do so.